I'm CJ Rosenbaum, and thank you very much for joining me again for Amazon Sellers News. Breaking news for Amazon sellers, where I can provide you with all the information from our entire team to help you avoid suspensions, how to get your listings back, and how to get your accounts back if you should suffer suspension. Today's breaking news, I want to focus on IP complaints, intellectual property right complaints, also called rights owner complaints, when you jump on a pre-existing listing. Now, we can divide these issues up between when you jump on a pre-existing listing when you actually have sales, which is what I'm going to talk about today, and when you jump on a pre-existing listing but you never had any sales at all. So if you get a listing suspension or an account suspension, here's what the latest news you need to know about. One, this is when the brand created the listing or another seller created the listing. If the brand created the listing, the chances of there being a significant or any intellectual property right violation is practically zero as long as you're selling genuine products. If another seller created the listing, the chances of there being an IP violation is a little bit higher, but if you're not the one that created the listing and you're not the one that scraped the photographs or cut and pasted or copy and pasted the verbiage, then in most states in the United States, you did not do the act, and therefore you are not violating anybody's IP rights. When you have actual sales and Amazon is giving you, or you have received an IP violation, you're going to have to show, that your product was genuine, either to Amazon or to whomever made that rights owner complaint. Proof of authenticity is vital, and you need to look at the warranty. Are you delivering to that consumer the same exact thing that the brand delivers to the consumer? When it comes to the warranty, most big brands have still failed to alter their warranty in a way that third-party sellers cannot deliver the same exact thing, and therefore you are protected under the first sale doctrine. Also, I want you to start vetting your suppliers a bit better. Better suppliers are more likely to have sold you genuine products, and more importantly, better suppliers will have easier to find links back to the brand, and this is vital. Now, how do we win these cases every day of the week? First, we win these cases by going to the complainant, the person or company that made that complaint, and seeking retractions from them when it comes to your particular sales by showing that it was genuine, that you did not violate any IP rights. You're not even the person that created the listing, and we get retractions. If we can't get a retraction, then we go back to notice dispute or even seller performance with winning plans of action that show you tried to contact the complainant, your products were 100% genuine, and you did not violate anyone's intellectual property rights. Also, I want you to know, and I can't stress this enough, legally, if someone else created that listing, the chances that you are actually violating anyone's intellectual property rights is extremely low if you're selling genuine products. Now, breaking news story number 2, used sold as new. There is an increase in the calls that we are receiving for used sold as new listing suspensions and used sold as new account suspensions. Packaging. Your packaging must be dead on to what the consumer will see when they visit a brick and mortar store. Third breaking news story has to do with prior course of dealing with Amazon as a way of overriding that ridiculously one-sided contract between every single seller and Amazon.com. We've recently been engaged in an arbitration, a drag-out, knockdown fight with Amazon, where the arbitrator gave us an incredible decision identifying that your prior course of dealing with Amazon might override that incredibly one-sided agreement. The way we fight these every day is we argue that the agreement is itself unconscionable and should not be enforced. Under the law, there are two different theories. There's procedural unconscionability, and there is substantive unconscionability. And if we win that argument, then it falls back to, well, what exactly were the terms of the agreement? And if Amazon has sent you notices that you then address, and then you're back to selling, that is what's called a prior course of dealing, which may may override that incredibly one-sided contract with Amazon. That's today's breaking news for Amazon sellers. Please join me again tomorrow, where we're going to address inauthentics, used sold as new, IP issues, and all the issues every day that Amazon sellers face from our 10,000-foot view from helping thousands of sellers, reinstating tens of thousands of listings, and saving tens of thousands of jobs all across this country. Now, if you like this video, if you've learned something, if I have helped you in any way with an IP issue that you're facing or helping you make better business decisions, please like this video, please share this video, and please join me again tomorrow for Amazon Sellers News.